Hello, my name is Dave Zapponi, and I'm the CEO at ECHO, otherwise known as the Educational Council of Homeowners. I want to thank you all for participating today in this community conversation, animals, parking, and other enforceable rules. ECHO is a statewide nonprofit association established to support HOA board members and engaged homeowners. Our mission is to foster a better quality of life in community associations through education, advocacy, and connections. For today's event, we have a few housekeeping items. These are now shown on the screen. In addition, slides were sent to registered attendees beforehand. Please take a moment and review the housekeeping items. We have many HOA board members in attendance today, which usually means a lot of questions. In fact, we have a record amount of people signed up today, over 400. We will do our best to answer all of your questions. Please use the Q&A icon, not the chat icon, to ask your questions or to make comments. You should use the chat icon to report technical issues and to communicate directly with other participants in the webinar. You will find these navigation icons by hovering over the bar at the bottom of the page. I will respond in writing to questions in the Q&A feature during the presentation. All other questions will be answered during the Q&A section at the end of the seminar, and I believe Jean is going to answer a few questions, one or two, after each of the sections of her presentation. Please keep your questions general in nature. Questions about specific situations are better asked one-on-one with your own professional. To help us select the most relevant questions, please use the thumbs up icon found on the bottom of the Q&A screen in the bottom left corner. Simply click this upvote icon to select your favorite questions. The upvote icon actually totals the number of people that want to have that question answered, and it really does help. And now for our disclaimer, which you'll find on the screen. None of what is said during this seminar shall be construed as specific legal or expert advice from the speaker, sponsors, or ECHO. If you wish specific advice, we encourage you to contact your attorney or other suitable expert. Thank you. Today we have several sponsors. Please join me in thanking our premier sponsor, the Kevin Boland Insurance Agency, and our program sponsor, Morris & Sons Towing, our Q&A sponsor, Rebello Towing Service, and today's registration sponsor, Levy Erlinger and Company CPAs. Now we will have a few words from our premier and program sponsors, Morris & Son Towing and Kevin Boland Insurance Agency. Connor?
To receive the most professional and efficient towing enforcement service available, follow these easy steps. Step 1. Sign up at the Morris & Sons Tow Club page. Step 2. Enter your property information and select your enforcement instructions. Step 3 and 4. Add the people you choose to enforce your parking and enter their information. You may include the tenants of their own stalls, board members, employees, or a security contractor for any and all areas at your site. Step 5. Sign the agreement and you're done. Our team will contact you shortly, review your agreement with you, and schedule the professional installation of required signage. After the installation of your signs, your account will be activated, and you will be able to request towing services via web with instant notification to our tow operators, and have access to view all activity at your site. Morris & Sons is committed to providing the most efficient service possible, and we work hard to make sure you can communicate with us directly, 24/7, 365.
Hi everyone, Kevin Boland here, Farmers Insurance Agent. I am very proud to be the premier sponsor again today for ECHO's educational webinar. And you know, I also sit on my board, and I've learned over the years it's much better to be cooperative than combative when it comes to handling homeowners. And the best policy when it comes to insurance is abstinence. However, that being said, if a homeowner or someone were to sue the board claiming discrimination based on age, race, ethnicity, sexual orientation, disability, or even claiming that they were being harassed because of their pets and animals, which we'll learn more about today from our attorneys, that is a covered type of claim that Farmers Insurance will indemnify the board for and defend them. And most carriers today will exclude third-party discrimination types of lawsuits, but Farmers Insurance will cover that type of claim. So I'm really proud about that. And real quickly, Farmers introduced a new type of crisis management coverage. So heaven forbid there's any sort of a violent act committed in association, Farmers Insurance now will pay $50,000 for extra security measures, for medical payments, and even funeral expenses. And they'll even pay for counseling. It's a really good new service that we hope we never need. So I'm looking forward today to hearing our attorneys speak, and thank you very much.
Very, very interesting, Kevin. We very much appreciate your sponsorship. We will also be giving away one $50 gift card courtesy of Divergent Consulting. I want to say thanks for that. Stay tuned until the end of the webinar for a chance to win that $50 gift card. Thank you to all of our sponsors. They make this event affordable to everyone. We will now move into our planned presentation for the day, presented by Jean Grove, Esquire of Kaufman, Dolowich, and Bullock, LLP. Jean Grove focuses her practice on real estate and business litigation, including HOA and co-ownership issues, purchase sale disputes and non-disclosure claims, and boundary title development and construction matters. Her representative clients include homeowner associations, real estate brokers and agents, developers, lenders, property owners, and business owners. Ms. Grove offers her clients nearly 2 decades of experience in mediation and arbitration, as well as all phases of civil litigation. Based on her deep litigation experience, Ms. Grove regularly counsels clients such as HOAs on how to avoid conflicts by strategically managing their day-to-day operations and compliance matters. Jean, it's all yours.
Thanks, Dave. So well-timed, we are talking about CC&R enforcement today. We will focus particularly on animals and parking, but we'll start with the fundamentals with respect to enforcing CC&Rs, enforcing operating rules, how to create operating rules in the first place, and what to do from A to Z. So without further ado, let's start with the first slide. Thank you, Connor. And we'll just start with some fundamentals. So first, the elements of the governing documents, which is essential to have a good handle on so that you know what your rules are, all your rules and regulations are in the first place. So of course, as many of you probably know, there's a declaration also known as the CC&Rs. There's also likely a condominium plan that you've seen, also often referred to as a condominium map or even a subdivision map. Those are the 2 critical factors, the 2 critical elements of governing documents for any HOA. In addition, you might see articles of incorporation, though not always. You might also see bylaws, though not always. There are also sometimes operating rules and then other related documents that might otherwise govern the property. So these are elective, but it's always worthwhile to proactively search for them if you don't have a good handle of what your governing documents comprise of. So those are the key elements to look for. Looking at the next part of this slide, how to enforce the governing documents. We often get questions about what if the bylaws are inconsistent with CC&Rs? What if the articles of incorporation say something different from the declaration? So I've organized this in somewhat of a hierarchy so that you know which questions to ask and in what order. So the first question in that first bullet point is to check the law versus your governing documents. The law can be more often than not the Davis-Stirling Act, first and foremost, but it might also include the California Business and Professions Code and maybe also the California Corporations Code. So when we start with that first question, check the law, That obviously means most likely you should check with an attorney, maybe not in every single instance, but at least have a check-in with your HOA counsel, just so you have a working understanding of what laws apply to you. And ideally, they can even tell you the civil code sections so that you can look them up yourself and at least have some handle on what the applicable law is. So check the law and then compare it to your governing documents. Does anyone know if the law is inconsistent with the governing documents, which one prevails? Can we do a chat or Q&A? The law, okay, good. Everyone knows the law prevails. Thank you, the statute, that's right. The law, also known as the statute. Exactly, so the law will prevail over any inconsistencies with the governing documents. And that often happens when the law changes, and we've seen a lot of recent changes in the Davis-Sterling Act. CC&Rs may not necessarily be updated or amended to reflect those changes. Obviously, the law supersedes regardless of outdated CC&Rs. So the next question is, what if your CC&Rs are inconsistent with the Articles of Incorporation? Does anyone know the answer to that? And let's look at the chat and see what people think. CC&Rs, okay. Does everyone agree? CC&Rs, I see it. Okay, great. So everyone is correct. CC&Rs, also known as the Declaration, prevails over Articles of Incorporation. Okay, the next is bylaws versus declaration or articles of incorporation. Does anyone know? So for example, if the bylaws say one has to provide a certain amount of notice for a meeting, but then the declaration or articles of incorporation say something else, what do people think about that? Somebody says bylaws, bylaws. Somebody said declaration. Okay, this one is a little less clear. So it's actually the declaration, also known as CC&Rs, or the Articles of Incorporation, both of which will supersede the bylaws. So that can be tricky because in that example I just gave, bylaws might say something about notice, and then the CC&Rs might say something else. It's the CC&Rs that will prevail. Now, more often than not, a good set of governing documents will just set forth all those notice and meeting requirements in the bylaws only, and the CC&Rs won't even talk about it. That's a good set of governing documents, but there are those ones that are kind of clunky, or maybe they created the bylaws after the fact. So just remember, CC&Rs or Articles of Incorporation do supersede the bylaws. And then finally, does anyone know about operating rules and where they fall under with respect to CC&Rs, articles, or bylaws? Somebody says declaration. All others, yep, I'm assuming that means the declaration, articles, or bylaws. Somebody says CC&Rs, exactly. So the answer is CC&Rs or articles of incorporation will supersede those operating rules, meaning exactly as somebody said here, Bruce Johnson, operating rules are last in line. And the statutory support for that is Civil Code 4205, in case you forget the order of operation. So those are really important questions as you're getting familiar with your governing documents and trying to harmonize it all, is really remembering this hierarchy. And then you get into, as you're thinking about procedures and next steps, do I have to provide notice to a homeowner of a violation and provide an opportunity to be heard? Are there fines that are applicable for this particular violation? So these are just questions you should be looking into. And then finally, are there IDR, meet and confer, or ADR requirements, or maybe all of the above? So these are really the preliminary questions that you need to look into whenever you are faced with an enforcement issue or a violation issue. Moving on, let's see, I see a question about operating rules. Let me get into what a rule is and how to make a rule and all of that, and then we can go back to some of those questions. So first of all, what is a rule? Civil Code Section 4340 defines that for you. And then Section 4350 talks about what are valid and enforceable rules. And so the basics are, it has to be in writing, it has to be within the authority of the board, which is quite broad, cannot be in conflict with the CC&Rs, et cetera, as we just established. And it must be adopted properly. We'll get into that in the next slide. And then, of course, reasonable. So with the next slide, we'll talk about how you create an operating rule. Or sorry, okay, this slide is about what it can apply to. So this is a common question we get where where homeowners or HOAs don't know whether something should be classified as a rule as opposed to something that needs to be amended formally in the CC&Rs. The statute provides all the different areas that where a rule should be a rule versus a CC&R provision, for example. So some examples of proper operating rules are member discipline, schedule of monetary penalties, even procedures for elections. What it cannot be is a rule on the maintenance of the common area. So for example, if CC&R say homeowners responsible for exclusive use common area, maintenance and repair of it, an operating rule could not try to change that. And you also cannot create an operating rule to establish assessments. So that's a little more color on what rules are. In the next slide, we can talk about how to create a rule or make a rule change. So section 4360 addresses the procedures for that. And really, it's just important to go through all of these procedures. It's not something you're expected to memorize, but do make sure that you're referencing this section whenever you are creating a rule. And just know that there are certain time notice requirements, such as 28 days before you can make the rule change. You have to provide notice. You have to provide the language of the rule, preferably as soon as possible, but at a minimum after the meeting and a decision is made after the meeting, you have to provide notice of that actual rule and circulate it to all the members no more than 15 days after that meeting. You should also set forth any schedule of monetary penalties at that time too, if that's part of your rule change. Whatever the case may be, whatever the scope of your rule, just make sure it's all in writing and it's provided in advance, and then you have that meeting. And keep in mind, the section provides these minimum time requirements. And so when it references notice, for example, you have to provide notice in advance of the text of the proposed rule, and then you have to have a board meeting on it. Keep in mind that your bylaws or your CC&Rs may have additional procedural requirements that you need to comply with in addition to the statute. So always remember that the Davis-Sterling Act and any other applicable law will always set the minimums, but the minimums may not be all that you have to contend with if your governing documents provide additional procedural requirements. So keep that in mind. One common example is if notice is by mail, for example, and the CC&R say notice by mail entitles you to 5 more days of service. Keep in mind that if it says 28 days here in the statute, you've got to add another 5 days on top of those 28 days. And same thing with 15 days, you actually want to move backwards and just make sure that you are serving notice of the rule change, preferably 10 days, so that your notice period is within the 5-day time frame provided in your CC&Rs, assuming it's allowing for 5 extra days. So these are just procedural requirements to be aware of when you're making these rule changes. Next slide. Before we get into monetary penalties, now let me address some of these questions around rules. Policy versus rule versus regulation. This is a good time to step back and make sure that we're all on the same page as far as terms. So what I just talked about, what is a rule? How do you make a rule change? I'm talking about operating rules, and you'll see that referenced in the statutes that I just listed in those previous slides. Policy isn't, or regulation for that matter, are not exactly terms in the Davis-Sterling Act. You might see them referenced in CC&Rs, and that's all fine. But what you have to always think about is if a set of governing documents is saying policy, it is the policy of the HOA to do XYZ, or homeowners must comply with this regulation XYZ. You have to see where it fits into the statutory scheme. And often regulation, if that's the word that's being used in your CC&Rs, just know that's most likely a rule. But again, it might be worth cleaning up the governing documents if they're using these kind of non-statutory terms like regulations, policy, and other non-statutory terms like that. So for purposes of this presentation, just keep in mind that when I said rule, I'm talking about operating rules under the Davis-Sterling Act. Let's see, what else do we have in the Q&A? I think these are highly specific, so I'm going to skip some of these really specific ones. I might address this one about a new rule being enforceable retroactively. That's a good question. The answer is no. The whole point of implementing a rule or rule change, and the whole point of providing adequate notice in advance of the rule change, is that you cannot apply it retroactively. Now, there were a lot of instances, especially in the last couple of years, where HOAs had to contemplate an emergency rule. And there is statutory support for that as well in those same statutes that I mentioned. As much as possible, the HOAs should still try to follow the procedures, even if they have determined that there is a quote unquote emergency rule warranted, for example, to protect the health and safety of the development. And of course, in the wake of the pandemic, that situation arose quite often. But it's a pretty high bar. And I would say the last 2 years is really the first time, for the most part, that we encountered circumstances that we felt warranted an emergency rule, such as shutting down a common area pool and having a rule if somebody tried to violate it and tried to access the common area recreational facility. And this was, you know, in the height of 2020 time, right? Spring of 2020. Nowadays, we're going back to encouraging HOAs to just follow the basic procedures for adopting a rule and try to avoid emergency rules whenever possible. But plain answer to retroactive application is no, you cannot apply it retroactively. So moving on to the schedule of monetary penalties, this is section 5850 of the Davis-Sterling Act. The simple takeaway from this section is that monetary penalties, schedules of monetary penalties, are allowed by statute. The HOA simply needs to follow the procedures which are set forth here in order to do so. And the key is to ensure that any schedule of monetary penalties is distributed to all the members. Preferably, a schedule like that is implemented at the time of the annual meeting or sometime soon before that, so that it can just be distributed as part of the annual policy statement. The statute does require that any schedule of monetary penalties be distributed at that same time. But more often than not, we have clients at least that decide they need to implement a monetary penalty schedule for one reason or another, sort of in the mid-year timeframe, which is allowed under the statute. The key is you just have to distribute it as soon as possible thereafter to all the members, and then remember to add it to the next annual policy statement that gets distributed as part of the regular schedule. And that's usually the trap, if you will, when you have schedules that are implemented mid-year, meaning not in conjunction with the annual meeting, because often we find that HOAs forget to add it to their annual policy statement. So that's really, in a perfect world, you just want to have it timed around the same time. But if you can't, it's fine, and you can still do it as long as you remember to distribute it in the next annual distribution. Let's see, any other questions on that? Is there a difference? I think we addressed the difference between rule versus policy. Does the notice of the rule change have to be made in writing by email, or will email or posting suffice? That's also a really good question. There are actually rules around notices. The key is to ensure that you are following your own governing documents. And then under the law, the 28 days notice, it's actually Civil Code 4040, I believe, which is not in my slides, but it is referenced in the slides that I mentioned. where you have to provide notice of your rule change. Let's see, it's 4045 of the Davis-Sterling Act. You just have to provide notice in accordance with that statute of any rule change, as well as any schedule of monetary penalties. And then on top of that, just make sure you're also complying with your notice requirements under your own governing documents. Does the 28-day cycle start again if changes are made during the meeting? That's a really good question. The answer is yes. So if the board is not approving the actual text letter for letter of that rule, that is identical to what was circulated prior, then yes, you have to recirculate it. Arguably, you have to actually conduct another board meeting and basically start from square one. The only exception, which is not provided explicitly by statute, but what we at least advise HOAs is if there is a typo, then a typo does not necessarily, in our view at least, warrant a redo completely under the statute of the rule change process. But a typo has to be exactly that. It can't be an ambiguous kind of substantive change. It has to be a true typo, like a word is just spelled incorrectly. If it's a typo in people's view, and let's say the rule is $50 per day rather than 500, that's a substantive change, obviously. Even if people may perceive that as a typo, it would warrant redoing that 28-day cycle and going through the whole rule change process again. Can a monetary fine be set to cover health and safety infractions? Well, so that's rather broadly stated. I mentioned in COVID times that we did have some monetary fines and some rule changes around access to common area recreational centers. And again, this was in a really short window of time that even over the course of the 2+ year pandemic and whatever you want to call it, ongoing COVID concerns, it really became moot by as soon as fall 2020 even. So I would say you can't do an infraction for health and safety as a general matter, but if there's a specific thing like you can't access a specific area of the development because of health and safety concerns, maybe there's a construction zone, that would be fine, but of course, subject to the proper procedures for making that rule. Let's see. I think I see some things on parking, which I'll skip for now because we haven't addressed parking yet. Amount of monetary penalty is another good question. The board generally has broad discretion in determining the amount of the monetary penalty. But again, it's all subject to the business judgment rule, and it really depends on the egregiousness of the violation in question and the reason why you are implementing the amount. If it's reasonably associated with the amount of costs that the HOA might incur to correct or remedy the situation, whether it's a cleanup of a common area or addressing damage to the common area, then that would be reasonable. You can't do something like 5 times the amount of the repair cost. I would say that's probably too high and may not be within the board's business judgment rule, but it really is on a case-by-case basis. So moving on to disciplinary procedures, this is Civil Code Section 5855. And this is really the first official step towards implementing discipline and enforcing an operating rule, for example, or a CC&R violation. And the first step is really to determine whether a monetary fine is allowed. So this is assuming you've got a schedule of monetary penalties. It's been distributed on an annual basis. The rule change was made in the past, and now you're faced with having to enforce that rule. In that situation, you do have to provide notice of a hearing or a meeting to that violating homeowner and give them an opportunity to be heard, essentially. And the notice has to have the date and time and place of the meeting. And then preferably you have a very detailed description of the alleged violation. The key is to provide adequate notice to the violating homeowner of what they did or did not do, and then have an opportunity to address it at the meeting substantively and determine whether the violation is in fact accurate and therefore whether disciplinary procedures are proper. At that meeting, the board has to determine whether discipline is in fact warranted. And then if they do so, they have to provide notice to that violating homeowner within 15 days following the action. I always say do it as soon as possible, but technically you have up to 15 days to serve that. Next slide. So this is about ADR and IDR and where this fits into the whole disciplinary procedure process. So in addition to that notice and hearing procedure that I mentioned just now in the previous slide, the HOA also has to determine whether there are IDR and ADR requirements before proceeding further with any enforcement procedure. So IDR stands for internal dispute resolution, which is a term codified in the Davis-Sterling Act. ADR stands for alternative dispute resolution. And they are different and recognized as different in the Davis-Sterling Act. And technically, they are both required before any formal enforcement action may proceed. So keep that in mind. IDR and ADR are required before an HOA can proceed with any enforcement action. And in addition, you have to check whether your own governing documents have yet more procedures on top of IDR and ADR. So often CC&Rs may say there's a meet and confer process. And so keep in mind, meet and confer is not technically an IDR, recognized IDR, but it is, for all intents and purposes, the same thing. And so if you look here actually at section 5905, it merely requires that an HOA provide a fair, reasonable, and expeditious procedure for resolving a dispute, such as an infraction or violation of the CC&Rs or an operating rule. And so as long as that meet and confer process is a fair, reasonable, and expeditious procedure, it will count as the requirement to conduct IDR with the violating homeowner. The key is that this procedure, and actually if we go on to the next slide, there's a little more to it under section 5910. The key is that the procedure cannot result in a fee being charged to the violating homeowner. So one example that I had recently was when prior HOA counsel was scheduling this meet and confer, AKA procedure, IDR procedure with the violating homeowner. And as a condition for that meeting, the attorney was attempting to charge the cost of her attorney's fees to the homeowner in order to conduct the meeting. That is simply a prohibited fee that an HOA may not charge as a condition to participate in the process. And there may be some ambiguity as far as which procedure they fell under, but in that case, at least, it was technically the first meeting of any kind with the violating homeowner, and there cannot be any fee whatsoever charged with that. And then just keep in mind, there's several other requirements as part of that procedure that the HOA must follow. For example, the HOA simply can't say no. So every homeowner has the right to invoke this procedure and the HOA must participate. It must be conducted as soon as possible. Sometimes your governing documents will say the outside timeline for when the IDR process must occur. And then of course, the association must actually participate. So they can have a contact person, one representative of the board, for example, designated to represent the HOA to participate in this process, but they can't just delegate this to a property manager, for example. It has to actually be someone who is a part of the association who is participating in this in order to strictly comply with the statutory requirements. Let's see. Before we move on, because I'm going to move on now to specifically animals and parking, let me see if anyone has general questions about rules. Let's see. Did the changes to any rules need to have a date on them to make official? I recommend you put a date on the rule change, just so that there's no dispute later as to the effective date. That's a good idea. Our HOA refuses to file the minutes of their meetings to the website. That I think might go more to logistics. So keep in mind, uploading any type of documents to a website may not comply with your notice requirements under the Davis-Sterling Act. So when we were talking about providing the schedule of monetary penalties, even your annual disclosures, all of that has to comply with statute. So certainly it's a nice service to have them all available by your website if you have one. You have to, in addition, also provide notice through all the statutory requirements, whether it's mail, individual delivery, or both. What happens if the HOA fails to distribute rules? Also a very good question. They are not valid. So that's why it's really important to follow all these procedures, cross your T's, so to speak, when it comes to rule changes, because if the notice requirements are not strictly complied with, for example, the rule is not valid, and then you get into trouble when you're trying to enforce it as to a particular homeowner. Does the board have to survey the membership before implementing a new rule? No, technically not. And no, the simple answer is no, that's not required. Where is the 28-day noted in the civil statute? That was in Civil Code Section 4360. If an operating rule was created and found to be vague, can the board strengthen the rule? Certainly. We've actually had instances like that where we created some anti-Airbnb rules, for example, anti-short-term rental rules. And over time, as Airbnb became more prevalent, for example, and we had a better idea of how to regulate that, boards certainly decided that it would be helpful to clarify what is or is not allowed, usually what is not allowed. And then, of course, more importantly, what the consequences were if anyone violated these short-term rental rules. So in that case, you just follow the same procedures for a rule change. And the key is just to make sure that you're following that strictly per the statute. The only tricky thing to that, by the way, is the rule, until it's properly changed and you've gone through all the notice periods, 28 days, 15 days, etc. The rule change does not take effect until all those timelines are complete. So your old rule may still be in effect up until that point. And when it comes to enforcement, you really have to figure out what is the date of the violation. And going back to my short-term rental example, that became a little tricky when the short-term rental violation was ongoing. Let's say it went from December to March, but then the rule change took effect in January. Well, we've got some time during the December timeframe that we were under the old rule. So it's really important to make sure you're on top of the scheduling and the timeline. We set up a schedule for fines and sent it to all homeowners before making it policy. Is that acceptable? Certainly it couldn't hurt. If you want to give advance notice and be as transparent as possible with your homeowners, no harm in doing that. Just be super clear about what you are giving them so that there's no question as to whether you're trying to satisfy the rule change procedures or the rule procedures, and just make sure that no one is confused about these additional documents that you may be giving them. I just realized I'm looking at the chat feature and ignoring the Q&A. Let me see really quickly before I move to animals. whether there's anything else. If an owner violates a rule regarding damage to common area and the owner agrees the rule was violated at the hearing, is any additional dispute resolution required before a fine can be assessed? The answer is no. In fact, it's only the hearing that entitles the HOA to start implementing the fine. And again, assuming those 15 days, within the next 15 days of the hearing, there is proper notice to that homeowner that the board has decided the rule was violated and here are the consequences, here are the fines. But the owner still has the right to request IDR and or ADR, but it does not freeze the time that the fines start getting imposed on the homeowner. So the only thing that freezes that is this hearing. And then of course the notice that is supposed to be served on the homeowner thereafter. So hopefully that's clear. If both an IDR and ADR are required, what should an HOA do if the violating homeowner refuses to participate or does not respond? Then that's all you can do. And we actually see that quite often where the HOA has agreed to participate and the homeowner is a no-show. You just have to document that as best as possible. Usually you've already got a third-party neutral involved, or you have some documentation scheduling the date and time of the IDR and the homeowner's a no-show. That's you as an HOA have satisfied your ADR, IDR requirement if the homeowner simply doesn't show up. Now, of course, usually what happens is a homeowner says they didn't get the notice, they thought it was a different date, whatever excuse they have. In those cases, I always encourage an HOA to make a good faith effort to reschedule it within reason, of course. The key is to document that proper notice of the date and time and location were provided to the homeowner, and then you can say it was a no-show. What options are available when the board does not operate in accordance with the governing documents? Well, a homeowner does have the right to enforce the governing documents as well. And so depending on the situation, of course, that can be addressed directly with the board on behalf of the homeowner. Can a board member ask for an IDR or ADR? With the association board, yes. So a board member can, on their own behalf as a homeowner, also ask for all of these same processes and exercise all of these rights under the Davis-Sterling Act vis-a-vis the board. There might be instances, of course, where that particular board member has to recuse themselves from executive session meetings, but theoretically every board member can also be in the shoes of a homeowner as long as it's clear that they are only acting on behalf of themselves as a homeowner and not on behalf of the board. Does the HOA have to pay a manager for being an IDR? Yes, that is the rub, unfortunately, that of course an HOA would have a contract with the property manager, and depending on the contract, of course, whether it's hourly, per meeting, whatever the fee schedule is, yes, that contract must be complied with if you expect the property manager to participate in the IDR process. Does email distribution count? The simple answer is not necessarily. There is a recent statute change in the wake of COVID that allowed email when personal delivery was required or provided for in governing documents. But that is contingent on the homeowner providing consent to email. So good practice is to proactively obtain that consent at the time that a homeowner first takes ownership. And that way, of course, get the email address and put the onus on the homeowner that it's their burden to update the HOA representative of any email address changes. That's good practice. But assuming you haven't done that in advance, then just keep in mind that email alone does not necessarily equate adequate notice. We still recommend you do it just for extra measure, but most likely you will have to provide notice in some other additional method, such as mail, maybe even personal delivery as needed. Okay, let's switch over due to time constraints to animals and parking specifically. So I have set forth several questions that come up with respect to these two common issues. And so read them for yourself. Due to time constraints, I won't repeat them here, but just keep in mind that we often get these questions when it comes to pets or parking or both. So we'll address that in due course with these next slides. Starting with pets, also known as animals. Civil Code 4715 talks about pet prohibitions and what HOAs cannot do with respect to pet prohibitions. So bottom line is at least one pet is allowed, and the pet can be any domesticated bird, cat, dog, or aquatic animal kept within an aquarium. I'll get to the myriad of exceptions to this general rule, but that is the general rule to start, that an HOA cannot prohibit an owner from having at least one pet, and pet being those categories I just listed. Okay, next slide. Service animals. So we'll get into a little bit about when HOAs have to provide reasonable accommodations. But just for your reference, here is the very lengthy definition of a service animal, which is typically regulated by some kind of certification. It has to be for the benefit of an individual with a disability, of course. And there are certain species of animals that are allowed. Often it's the type of dog breed that is allowed for service animals. So that's just something to be aware of. Next slide. Then there are emotional support animals. So when we're talking about emotional support or service animals, these are considered exceptions to that basic rule on pets that I mentioned earlier. The one pet cannot prohibit at least one pet per unit in an HOA. The exceptions include emotional support animals and service animals. And while service animals is a much more clear-cut definition, emotional support is a very loosey-goosey, very broad, often dictated by case law type of category. As you'll see here, the California Health and Safety Code has a definition that it provides emotional, cognitive, or other similar support to an individual with a disability, but it does not need to be trained or certified. So it is fairly broad. It does, of course, require that the person be disabled in order to trigger the right to emotional support animal. But what type of animal is allowed ends up becoming a hotly litigated issue. Next slide. So the Fair Housing Act defines a disability to include any one of these three categories that are listed here. And I won't repeat it, but definitely take a look so that you have a working knowledge of what disability includes. It is fairly broad. There are certainly several examples that are provided within the statute, and you'll see that in the second bullet point as far as at least physical or mental impairment. But at the end of the day, it can be a number of different things, and you'll see the language says includes but is not limited to. So it's a very broad category as far as what a disability is and what triggers an HOA's obligation to provide a reasonable accommodation for a person with a disability. Next slide. This is a little more about the disability definition. Again, take a look at this on your own time and just make sure you have a working knowledge of what it includes, both physical and mental disabilities. Next slide. Reasonable accommodations. Okay, so the Fair Housing Act, both federal and state, require HOAs in California to provide reasonable accommodations to persons with disabilities. And that means, of course, service animals and other assistance animals, but it also includes emotional support animals. So how do you execute reasonable accommodations? That's usually a very fact-intensive inquiry, and it can involve any number of issues. It can mean a variance from the operating rules, meaning all those rule enforcement procedures that we just discussed, they may be completely off the table because you have to provide a reasonable accommodation. So that's one example. Same thing when it comes to CC&Rs and other rules and regulations that govern the HOA. It also may involve architectural modifications, meaning physical modifications to the property. In general, Civil Code Section 1360 requires HOAs to allow disabled owners to make modifications to their own units, and sometimes to common areas at the owner's expense in order to accommodate the owner's disability. So one example that we had recently was an autistic child of a homeowner who was attempting to use common area in violation of the operating rules. And the operating rules were fairly simple in that you could not ride bicycles or any other vehicles other than parking cars in the parking garage. And unfortunately, this autistic child really liked riding her bicycle in the parking garage, which was a danger to everybody because of the way it was configured. In that instance, a regular rule enforcement obviously would not apply because the homeowner, of course, claimed a disability on behalf of their daughter, and we had to address it in a more meet and confer process and come up with a solution that accommodated her disability without creating a dangerous situation, which is what that was. So that's a perfect example of a reasonable accommodation. Next slide. Fraudulent claims, I just mentioned this because it is out there and it is a way to police homeowners, all parties for that matter, from fraudulently claiming the use of service animals. So it is some built-in policing, if you will, but keep in mind, this statute only pertains to service animals. So there isn't anything like it for emotional support animals, and query whether, if a homeowner is in fact truly disabled, whether they have a little more leeway, and I argue that I think they have quite a bit of leeway in terms of establishing the need for emotional support animals. So just keep that in mind. It really is a difficult scenario when an owner has claimed properly a disability, and the scope of an HOA's obligation to provide a reasonable accommodation can be quite broad. So I'll stop there and see if anyone has questions around that. What does one pet mean? I think I addressed that, those several categories that are set forth in the statute. Any limit on emotional support animals, as I mentioned, very fact-based. So it really depends on how the HOA can provide a reasonable accommodation, what other competing factors that the HOA is dealing with. So there's a question here about pit bull dogs allowed. Often pit bulls are not even covered in insurance, and maybe Kevin can actually help us on that front. If that is an uninsurable situation, that would be a very good basis for an HOA to say no to a request for a pit bull as an emotional support animal. How can an HOA tell if it is an emotional support animal? Verbal. Preferably we have it in writing. Verbal is not usually enough, though a verbal communication may be enough to communicate the request for a disability and put the HOA on notice of a disability. But if that has happened, we actually advise HOAs to follow up in writing and say, thank you, so-and-so. We are just confirming that on or about June 7th, we received a phone call from so-and-so homeowner that they have a disability, something like that. So of course, better to document things like that. Can service and support animals count as the one pet allowance? The answer is no. So when we talked about that basic rule on pets, one pet per unit rule, that's just the baseline basic rule. And then all of these service and emotional support animals are exceptions to that rule. What if a reasonable accommodation is extremely expensive, 10,000? Is there a limit? No statutory limit. It's all based on what is reasonable. And that is very fact intensive, unfortunately. Can the HOA limit the kinds of pets? Cats only, no dogs? The answer is no. So if you look at that statute, it says any of those domesticated animals. So to comply strictly with that one pet rule, it has to be any of those allowed categories. Does the pet policy apply to guests of HOA members? Yes, presumably it would be for all residents and occupants who are living on the development. And when it comes to emotional support animals, what is the scope? So this is what I addressed earlier, fairly broad, very fact intensive. It really depends on the situation. Large dogs who are service animals without identification. So there are a couple of things there that I want to mention. Service animals are typically certified, they have documentation, so it's pretty easy to confirm one way or another whether you have a service animal. And this is, of course, assuming the owner has established the right to a service animal, and that's usually well documented. If they cannot, and they're resorting to the need for emotional support animal, which homeowners often do, if they can't come up with the proper certification, then the question is whether the quote unquote large dog is reasonable. And that's where you go back to very fact intensive. It depends, you know, what is the situation with the unit, the configuration of the property as a whole, any other issues, are there insurance issues with having certain breeds, all of that. What if the emotional support animal is aggressive? This happens often when the animal is ultimately approved, but then the conduct of that animal becomes a problem. And frankly, that could be any pet, right? But if that happens, then the HOA is entitled to reasonably regulate that animal. You could go back to all of those rule enforcement procedures that we discussed earlier in this presentation. But ultimately, you could eventually prohibit that animal if it's warranted and the conduct is so egregious that it becomes a danger to others in the development. But again, very fact-based, and I would recommend, if that's the goal, that you really take the long game and document it and have multiple attempts to work out the situation so that you are establishing as an HOA that you have attempted to provide a reasonable accommodation and that this has crossed the line of reasonable versus unreasonable. I think a lot of these are a little repetitive. So pit bull question, size. Do violations of pets have to be complaints from homeowners? Not necessarily, but it helps. So when you're trying to build a case, not that I would necessarily solicit complaints from homeowners, but if you have them, definitely keep them on file because it helps to establish whether an HOA is acting reasonably. Okay, so let's switch gears now to parking with the next slide. And the next several slides, just to warn you, are really just a repeat of Civil Code 4745 on electric vehicles. And I won't go into them in very much detail, but it's definitely a good reference point and a guide for you if you are undertaking any kind of change to the property to accommodate electric vehicle charging stations. It's quite detailed, but helpful at the same time because of its detail as far as what you're supposed to do and what you cannot do. And the main takeaway is that HOAs are required to provide electric vehicle charging stations for its homeowners. There is a reasonableness in there, a reasonableness standard, but ultimately, as you'll see here at the bottom of the slide, reasonable restrictions cannot significantly increase the cost of the station or significantly decrease its efficiency or specified performance. So that's kind of the built-in caveat to reasonable restrictions of any charging stations. Also keep in mind that bullet point right above it, it is the policy of the state to promote, encourage, and remove obstacles to the use of electric vehicle charging stations. The HOAs have to contend with that, meaning if it's a close call, it will tip in favor of installing an electric vehicle charging station. Next slide. Again, a little bit more color for the requirements of it. Has to basically comply with all governing statutes, all building codes, zoning, ordinances, you name it. And the next slide has a little more on that as well. Architectural standards, if there are architectural modification procedures in the CC&Rs, then a homeowner has to comply with those same procedures, just like anything else. It's just that on top of that, HOAs do have to be mindful of their obligation to provide the charging stations within reason. And then the next two slides are just more about that as far as costs, maintenance, repair, insurance for it. And then the next slide after that is the final slide on electric vehicles, just making sure that they are complying with all applicable codes. Okay, so this slide is about handicap parking and providing reasonable accommodations for that. There is a case, a federal Second Circuit case that says HOAs are required to reasonably accommodate a disabled resident's request for special parking. What does that mean? Depending on your development, it might mean that the HOA has to provide handicap parking, quite simply. If that's not feasible, then again, you go back to this fact-based inquiry as far as what is a reasonable accommodation under the circumstances. If it is cost prohibitive or nearly impossible without having to significantly configure the common area property in order to create handicap parking, to what extent does the HOA have to provide parking for a disabled resident? It really depends on the cost and what they can do to try to accommodate that particular resident under the circumstances. The next slide is just a quick slide on towing, and Vehicle Code section 22658 provides all the rules around it. In essence, it allows HOAs to tow, and here are all the prerequisites for doing so. You've got to have a sign in plain view. It's got to be 17 by 22 inches. You've got to have it where it says clearly that it prohibits parking in a particular area. It has to have the telephone number of the local traffic law enforcement agency, et cetera, et cetera. So that's actually one of many ways that the HOAs would have the right to tow. There's also other instances, for example, if the vehicle is simply illegally parked on somebody's private property, that might be another basis. So take a look at these 4 bullet points in closer detail as well as the statute. I see a question about towing and guest spots. Preferably you have the sign in plain view, but if it's a guest spot that's not tied to a particular homeowner, then most likely you need to have this towing sign. So the HOA would have to satisfy all the requirements in this first bullet point of section 22658 before they could tow. As opposed to a dedicated parking space, if a car is illegally parked in a dedicated parking space and that is associated with a single family dwelling, take a look at bullet point 4 at the bottom of this slide, and it would likely fall under that scenario, and it would entitle the HOA to tow. Let me see here. I know there were a few more straggling questions on pets, but anything about parking? Does the HOA have to pay for the charging station? No, that can be that the HOA is entitled to require that the station be maintained and paid for by the owner. Can the owner use the common area plug? So that's another tricky question. If it requires common area utilities, the HOA is entitled to require that the owner pay for that portion of the common area utilities, but of course, as a practical matter, that is impossible to apportion to that one owner. But this is where, if it's a gray area like that, and it's not ideal to plug into a common area utility, but that's the only way that you can install the charging station, then unfortunately, the HOA is stuck with allowing it. And what we have recommended is you just set an estimated amount on a monthly basis that the owner is required to pay as a condition of that. So to be clear, HOAs are not required to pay for the EV charging station, but they are required to provide it. The only exception is if it is physically not feasible and cost prohibitive. But that is just like the reasonable accommodation rule. It's a very fact-intensive inquiry, and more often than not, the HOA will be required to provide the EV charging station, albeit at the owner's expense. If we put a charging station in visitor parking, does this make our HOA a public facility? That's a little, I would need to know a little bit more. If by visitor parking, that is parking available to the public, then yes, that's likely a public facility. But if it's only visitors that are tied to the development, meaning the owners, then it's likely not public. And I'm not sure what relevance that would have anyway for a charging station. So hopefully that addressed at least part of that question. Can we restrict owners using the open handicap parking and require them to use their own reserved parking spot? Assuming the owner is not disabled, yes. If it's designated handicap parking, in fact, that should be enforced, and the owner should be told to move their vehicle, assuming they are not handicapped and do not deserve the parking space. If homeowners have a garage, does HOA have to provide handicap parking? Not necessarily. So this goes to whether there is a public facility. Maybe that was the part of the question I didn't address yet. Public facilities mean that ADA applies, and ADA would require handicap parking. So probably we don't have time to get really nuanced on that, but just in general, it's good to know that public facilities are required to have handicap parking. HOAs may not always be public facilities. So that's something to keep in mind. Do you need an architectural modification to add a charger, or is that up to the HOA? That will depend on your governing documents. If there are provisions around making modifications to common area, which likely there are, a homeowner must follow those basic rules. There might even be specific rules relative to EV charging stations and how to request one. But in any event, that needs to be followed. And then ultimately it's up to the architectural board, committee, whatever there may be, or maybe just the HOA board at large to decide it, but that they are subject to the EV charging statutes, 4745 of the Civil Code. We can tow an unregistered, unoperable vehicle from a carport, correct? And actually this slide that's up right now, section 22658, it would be bullet point number 3. That is the authority for an HOA to do that. If all HOA owners have an enclosed garage, does the HOA have to provide common area open charging stations? Not sure what that means, open, and I am not even very familiar with installing charging stations if it has to have proper ventilation, if that's the question. But ultimately, these are things that are subject to the local codes, building code, local ordinances, and what have you. And so the general rule is it just has to comply with all of those codes. Likely you're getting a permit, and the local agency, the city or county, whatever the case may be, is the final arbiter on what is the proper installation of that charging station. Let's see, a lot of these are repeats. Can you tow with an assigned parking space? Yes, it needs to be improved with a single family dwelling. So this is basically if the vehicle is on either an assigned parking space or on the lot itself, then the HOA can tow. Let's see, I'm not sure if I followed that question about EV station apply to single family home developments where owners have the ability to install their own. So yes, if the association is comprised of single family units, then like a planned unit development, then yes, this statute, the Davis-Sterling Act still applies, and the governing documents would presumably dictate how a homeowner is to go about installing that EV station. If there is some general flexibility, in other words, if the homeowner is not required to seek approval of alterations to their own unit, then that means the homeowner does not need the board approval to install the EV charging station on their own parcel of land. Let's see. A lot of these are repeats. Okay. House rules. If the house rules state, for example, cars parked in no parking zones will be cited, subject to a fine and possible towing, but there are no signs up indicating the tow company, can this be enforced? No. So you could have a house rule or operating rule for sure that reiterates the rules around towing and whatnot. But unless it falls in one of these 4 categories here on this slide, then the towing still cannot take place. And that's simply because of the vehicle code. So unless, of course, you fall under, let's say, bullet point number 3, and it's on private property and lacks an engine, transmission, et cetera. But if we're just looking at general towing because they're in the wrong spot, you still have to have the no towing sign in plain view. All right, am I running out of time, Dave?
No, we have 15 minutes, but I was thinking we could go ahead to the Q&A now.
Okay.
Next slide, Connor. And then let's go ahead and ask the members to take a look at the questions and do their thumbs up. And we have the upvotes. There's in the upper right-hand corner of the screen, so I can see how many have the most thumbs up. Can you see that too, Jean?
I can.
Okay, so go ahead and ask those questions, and we'll give them a couple seconds here, Jean, to read them and review them. But you're probably going to get those 2 10s right there, right off, and we'll take that first page and just try to address those more complicated questions.
Sure. And I'll just go from scrolling up to down. So starting with that one early on about persons under 14 years of age being accompanied to a public pool. I assume this would be a common area pool. Assuming that's the case and we're talking about HOA enforcement, then yes, that's a reasonable rule. And can you regulate young persons when crossing driveways? So this is all involving enforcement as to minors. You really can't pursue a claim against the minor, but you can at least pursue the claim against an owner who's associated with that minor. And usually they're associated with one or more homeowners on the development. So that would be who you pursue. Okay. On account of any underage.
Okay, so the number one vote getter here, upvote, there's 2 of them. One is from Bradley Verona, and he asks, how can you deal with homeowners that try to hide behind? Well, yes, it's in the CCRs and bylaws and policies, but you haven't been enforcing it for the past 2 years. So I don't believe that I have to obey the rules. This specifically is in reference to an illegal resident parking in a guest-only parking spot. So how do you deal with rules that haven't been enforced or governing documents that haven't been enforced?
Well, yes. So if they haven't been enforced, but it's still a rule on the books, then the board does have the right to enforce it, despite what may or may not have happened in the past. And ultimately, if a homeowner is using that as the sole basis to not comply, eventually it will catch up with them. In that, as long as the rule is still valid and no change has been made, it can be newly enforced by the board. The only caveat to that is if there's some claim, for example, that an owner is being unfairly discriminated against, or singled out for some reason. And that is indeed the risk of a board who has not regularly enforced rules in the past. That would be the only caveat. But at the end of the day, it really depends. So if it's a no parking rule, for example, and there's good reason to start enforcing it now, and maybe the board has a reason that did not in the past, that will eventually carry the day and weigh in favor of the board enforcing it now.
Okay, well, here's a parking question from Carol Zimring. She has 13 upvotes. How can you enforce the guest parking? We have many homeowners that continue to park their cars in guest parking, and some of them are on the board. So how do you enforce that?
That is even more tricky.
Strategy.
I mean,
that's a strategy question.
yeah. Well, and that's why it's actually all the more important to enforce the rule. If it's a guest parking rule and the board or certain board members are violating it, it is really important to be transparent and show that the rule is being uniformly applied against those board members. There should not be any cherry picking there, because that's where the board could really get into trouble if other homeowners start complaining about that.
Okay, so what do you suggest they do about it?
Well, just like any other rule or disciplinary procedure, the board as a whole has to pursue that. And then they have the right to excuse the violating homeowner who's on the board from participating in any votes against that same homeowner, right? But basically the same disciplinary procedures should be followed, and promptly. Okay,
so let's take it one step further. So the board's in cahoots and they just say, even the ones that aren't involved say, we don't want to deal with this. Can she then turn around and enforce it herself as a homeowner? And how would she?
Yes. So yes, the answer is yes. And the way that the sole homeowner would do it is to make a formal complaint against the board and attempt to enforce the governing documents that way. Usually there's an IDR or ADR requirement, and then eventually if the board still refuses to enforce the rules as against themselves, then that homeowner has the right to file a formal enforcement action, just like any other homeowner.
Through the court system, or
depending on what the CC&R say, it can be through the court system or through a private arbitration.
Got it. Kevin Boland asks, we have a large pit bull who has charged one or two people in their development, but owner manages to call them back in time, so there's no damage, but it's threatening. Does the board have a duty to do anything? The board have a duty? And if so, what do you recommend?
This is really tricky, because in general, HOAs actually have an affirmative duty to protect its members and occupants on the development. And if they are on notice of potential threatening behavior by a pit bull like this, arguably the board does have an affirmative duty to do something. And the something is the operative term. Under those circumstances, at a minimum, I would recommend that the board create a paper trail, documentation, addressing that homeowner, documenting the issue, and perhaps maybe even suggesting some ways to protect others, such as preventing the owner from bringing their dog to the larger common areas where more people are likely to walk around. Something that shows that the board is doing something proactively to protect its members.
Okay. Well, an anonymous attendee writes, we have strict parking rules that both cars should be in their garage. Nothing should be placed in the garage that precludes parking both vehicles. A homeowner's garage has racks and boxes that allow only one car. This has been going on for years and years. Our board president is the offender and sidesteps this issue. He also does not allow enforcement of any other parking violations. This creates a huge problem. So that's a statement. What do you do about it?
Well, so we're talking about parking
Yep.
and
Requirement to park both vehicles in a garage, and they just don't require it, and because they're using their extra square footage for other purposes.
right. And again, assuming the governing documents state clearly what you can and cannot do with that space, then that ought to be enforced. And that happens a lot in our practice where a parking space is used even partially for storage, and that needs to be strictly enforced. And that can be a slippery slope if a board is kind of letting certain things, tolerating storage of certain things for a while, and then it becomes either one homeowner abuses that and it's, a hoarding situation, or all of a sudden you see nearly every parking space is using their space in some manner for storage. All the more reason to just remember to enforce those issues as promptly as possible and uniformly as possible.
Okay, so moving on to Sandra Goldman's question. She wants to know if you have a chronic violator, an offender, can you have punitive fines against that person? And I think she's talking about pets not being on a leash and what have you. I do want to say some of the homeowners out there might be interested to know that there are DNA tests that you can use to figure out whose dog is what and require the DNA. A little extreme, but they are out there. So what do you think about this? Can you do a punitive action?
Well, you just have to keep applying the monetary penalties, unfortunately. And I, in fact, have a chronic violating homeowner hearing coming up soon. And it's very tempting for an HOA to want to take more egregious action, more punitive action. But the reality is they're stuck with their schedule of monetary penalties, and they just have to apply it in almost rote procedure over and over and over again. And yes, you can eventually take it to the next level, assuming you've satisfied IDR, ADR requirements and what have you, to maybe eventually file a formal civil or arbitration action against that homeowner. And sometimes that's warranted depending on the chronic violations, right? But usually the hope is once you amass that amount of monetary penalties and it turns into a pre-foreclosure proceeding, let's say, that eventually gets the attention of at least most homeowners.
Yeah, but you could have your rules schedule increase, first penalty, second, warning on the first one, second one, third one, until it's 100 times the.
True.
Okay, so
that's right.
There is a way, but it's not considered punitive.
It's not considered punitive, and the key is that it has to be a pre-existing schedule. So if you're stuck with your schedule and you wish that in the past you had put that escalating schedule of penalties, you can't go backwards.
Yeah, so those are the things I can come up with. So there you go. Andrea, let's see. Andrea McArthur says, is the board or of an HOA responsible for enforcing parking violations? Example, if an unauthorized vehicle is parked in a non-guest parking place, do they have to enforce it? Please note, the board does not always know who is authorized to park in a designated space.
So there are a few issues and best practices I recommend in that case. If it's not too late, there should be preferably a procedure in place where you can monitor whose car is whose and put the onus on the homeowner if they have any vehicle change, even if it's a temporary rental, that they have to proactively inform management of those changes. So ideally, you do have a better sense of whose cars are whose. And if assuming you have that in place, then you can better police if there's an unauthorized vehicle present.
Okay, and then here's a pool question for 14 years or younger by Theo. And Theo says that in California law, it stipulates that a person under 14 years of age be accompanied by an adult when at a public pool, presumably due to potential hazard. Can we regulate young persons when crossing driveways on common areas? I think we touched on this earlier, but did we? Okay.
Yeah, the brief answer is you would go after the homeowner that's associated with that minor, And yes, you can enforce certain restrictions like that where minors are not allowed in certain areas unaccompanied by an adult.
Well, I also think, is the common area pool a public pool or is it a private?
Yeah, I couldn't tell. I was assuming that was a common area pool. Different scenario altogether, of course, if we're talking about public pools, which
Yeah, I think the definition changes by your jurisdiction too. So Orange County is a little bit, we found that as an issue during COVID, that happened quite a bit. So we're gonna go ahead and move on. I'm gonna go ahead and conclude this. You want to take one more? We'll take Lynn's question last, and then we'll go into the closeout here. I think we're at we're almost at 2:30, so we'll go ahead and do that. So Lynn Felsky asks, can an HOA board of directors enforce CC&R's changes when notice was not provided to the members? Not all members received ballots. Inspector of elections selected and ballots counted without any notice of the ballot counts on a meeting agenda. Does this invalidate the ballot? I think that's two questions, actually. The first question is does the board of directors enforce CC&R changes when the notice hasn't been given to its members? Oh, she's run away. Just hold on just a second there. No, it looks like we lost her. So I'm gonna go ahead and move on to the close because this was the last question. In any case, we'll just go ahead and move to the final. Give me a second here. I'll get all organized with my final announcements. I want to say thank you to everybody for coming today. I appreciate all of your time. Let's see. Okay, I want to thank you all, and especially for those that sponsored our event today. Without them, we wouldn't be able to have this event free to everyone. And I want to especially thank all of you that are members of ECHO. And if you're not a member of ECHO, I would invite you to become a member of ECHO. We do more than 60 online events a year. We're starting to do in-person meetings as well, and we would love to have you here. If you're a board member or a former board member, we have a special program for you. It's called the ECHO Board Members Club. The Board Members Club is open only to ECHO members who are board members or have been board members. And the limitation is just for board members. So if you haven't been a board member, you're not invited. And that means if you're a vendor, that we don't allow the vendors to come either. So it's a peer-to-peer learning and a really safe environment to have conversations with fellow board members on certain things affecting you. I think the next meeting is June 14th, and it's from 5:30 to 7 o'clock, and we'll be talking about reserve studies, and the following meeting is going to be about budgeting and budgets. So it's a really good thing to do if you are a board member. They have some amazingly good strategies that come out of that. For those of you who are interested in meeting in person, we have started our in-person regional panels. These are small groups that get together. The next regional panel will be the North Base Resource Panel on July 13th in Novato. They'll be discussing water conservation and fire prevention. And if you're interested in signing up for the Board Members Club, you can go online or you can talk to Patty Curzette of my staff. It's been a fun program today. It's always interesting when we do rules and rule discussion. It can be kind of conflicting, and understanding your governing documents are important, and enforcement is always important. People, pets, and are always and parking are always the three big things for rule enforcement. And we hope that you enjoyed today's program. And once again, I want to say thank you to our sponsors who've made this broadcast possible, and of course to all of you who participated today in our webinar. ECHO appreciates your investment in education to build a better HOA community.